Ladies and gentlemen, I welcome all to my channel. I am Razia Kali. Today, let us see a new criminal law, a new criminal act, namely the Bharatiya Nyaya Sanhita 2023, which is implemented in India on 1st July 2023. Initially, we have a penal law, a criminal law called Indian Penal Code. It was passed during the British regime in the year 1860. So that act, that criminal law, that criminal Indian Penal Code was there in India for more than 163 years. It was passed in the year 1860. It has been in use till 2024. So it was repealed only now from 1st July 2024. A new act, Bharatiya Nyaya Sanhita, came into force. Now the present government has passed three acts. One is called as Bharatiya Nyaya Sanhita, which replaced Indian Penal Code, and two more acts, namely Bharatiya Nagarik Suraksha Sanhita 2023 replaced the Criminal Procedure Code, and the Bharatiya Sakshya Adhiniyam replaced Indian Evidence Act. So the three acts came into force with effect from 1st July 2024. Now there are some objections regarding this new act, but it has been passed but all the three acts has been passed by the power parliament, and it was also implemented with effect from 1st July 2024, and so we are in a compelling circumstances to know the law, the new law, and we have to enrich our knowledge about this new law that will helpful for our day-to-day practice. And so I just wanted to share the important elements, key aspects of the new act. Regarding the name, the present government has chosen Bharatiya Nyaya Sanhita to replace the Indian Penal Code, and Bharatiya Nagarik Suraksha Sanhita to replace Criminal Procedure Code, and Bharatiya Sakshya Adhiniyam to replace Indian Evidence Act. My opinion is that they ought not to have just changed the name. Previously, when our government replace or repeal the old act, they do not change the name of the act. For instance, the Company Act 1956 was repealed and the new Company Act 2023 was passed. So there was no confusion among the people, especially to the advocates, judges and officers and police, with respect to when they are public, when they change the new act, when they pass a new act, so that will not give unnecessary confusion. Now the wordings, mostly probably these wordings are from the this Bharatiya Nagarik Suraksha Sanhita. This means that almost these are all the Sanskrit words. I feel that they ought not to use these Sanskrit terms. For the interest of justice or for the interest of convenience, they ought to retain the old name and let them have Indian Penal Code 2023. If it was passed like that, it will be comfortable to all for the day-to-day practice, for day-to-day usage. So I feel that it is somewhat difficult to even to the advocates, the judges, or the officers to pronounce or to use this new term, to Sanskrit term, which is not practicable. It will unnecessarily create trouble practical difficulties to the lawyers and to the public, for the even to the police officers. And I feel that they ought to have retained the previous name itself for these three criminal laws, which would be very helpful, which may not give unnecessary trouble or stress or difficulties for the day-to-day usage. So, as far as the first Indian Penal Code is concerned, which was passed in 1860, it had about 511 sections. But this present Act, BNS Act, has only 358 sections. So, some of the sections were removed, and some of the sections were codified and simplified, and so that the sections has been reduced to 358 when comparing to the old Act of IPC, which had 511 sections. The second important thing about this Act is that this BNS Act is that it has the offences against women and children were scattered throughout the Penal Code. Now, all the offences related to women and children have been consolidated under a single chapter in chapter number 5. That is one of the speciality of this present Act. Again, the offences related to the human body is also placed under next chapter, chapter number 6. That is also brought into a single chapter. Regarding the offences, three incomplete categories of offences like attempt, abatement, and conspiracy has been brought under the one chapter, that is chapter number 4 of the present BNS Act. So another important element is the community services has been introduced as one of the new punishments under the new Act. Previously, there were life imprisonment, the death penalty, rigorous imprisonment, simple imprisonment, fine, penalty alone will be the punishments, categories of punishment available under the old Act. Now the new category, namely community services, for simple offences like for non-appearances or some attempt to commit suicide. For these things, the community services has also been introduced as one of the punishment under section 4 of the BNS Act. Then the abatement of an offence committed in India by a person outside India has been made an offence under section 48 of the BNS Act. See, supposing a person, so as far as the criminal law is concerned, this criminal law is applicable only to the persons and to the commission of the offences committed within India. Suppose a murder is committed in India, the Indian courts can try and the persons who committed the offence can be punished by Indian court. Suppose the murder is committed in somewhere in Australia or America, so the Indian courts cannot punish those persons, and that will not amount to an offence under this Indian Penal Code. Supposing as per that is a criminal law, the territorial jurisdiction is concerned, is an important element with respect to the implementation of the criminal law. Now, under this new section, supposing a person who abets the commission of offence from outside India, suppose he was in America and Australia, and he instigates or he prepares and he abets for the commission of offence in India, in such cases, the person who abetted the offence, who was residing in outside India, shall also be punished under this new provision, that is section 48 of the BNS Act. So now another important element is the new offence for having sexual intercourse on false promise of employment or promotion or by suppressing the identity has also been created under section 69 of the BNS Act. Supposing a person had a sexual intercourse with a woman, saying that I will marry you subsequently, or supposing a person had a sexual intercourse with a woman, saying that I will give you promotion or I will give you some. Suppose he suppressed his identity, he had a sexual intercourse. Such type of things have been created as an offence under the section 69 of the new act, this new BNS Act. And regarding this snatching, you may have seen chain snatching in several cases. Previously, the chain snatching has been categorized as a theft or robbery. Now, a specific section has been introduced, that section, namely the section number 304, that speaks about the snatching, and the chain snatching or snatching itself is categorized as an offence under the new act. Previously, the age parameter for the different for differential punishment for gang rapers was there in the Indian Penal Code. Supposing a minor committed in a gang rape, suppose one of the person is a minor, then the minor will be awarded only a simple punishment rather than the major of the person who was the adult persons. So under the new act, the age difference is removed, and even if the minor commits this gang rape, the same punishment which is awardable to the adult person will be given to the minor. So that is the one of the difference between the old act and the new act. Then assault or use of the criminal force to a woman with the intent to disrobe her or voyeurism were made as neutral gender under section 76 and 77 of the BNS Act. So the assault or the criminal force to a woman has been newly introduced as an offence under the new act. Then the act of hiring and employing or engaging a child to commit an offence has also been included as an offence under section 95 of this BNS Act. This was made with the intention to curb the employing of or engaging a child to commit an offence. Now the new act, section 106/2 of the BNS Act was introduced, in which whoever causes death of a person by doing any rash and negligent act and escape from the scene of the incident is also categorized as a new offence, and it is punishable for the imprisonment for a 10 years period. Supposing a person when he was driving a car, caused a death to a person and he ran away without informing the next police or the magistrate, then such type of escaping, causing a death plus escaping from the police is also categorized as a severe offence, for which an offence of 10 years has been implemented through this section 106 of the BNS Act. Previously, there was no such, it was not categorized as such a serious crime. Then the organized crime and terrorist acts are also categorized as for offences also. Deterrent punishment has been given and the punishment level has been increased. Then the offences relating to the importation of the persons from foreign country has been made gender neutral to cover both boys and girls under section 141 of the BNS Act. Previously, there was an offence called sedition. This sedition was dealt in section 124A of the IPC, and the said sedition is removed in the new act. Regarding the attempt to commit suicide, it was considered as an offence under the old IPC. Now that attempt to commit is removed. On the other hand, section 226 was introduced, wherein the person who attempt to commit suicide with an intent to compel or restrain the exercise of a lawful power by a public servant has been categorized as an offence under section 226. Supposing a person who went to the government office, to collector office or tahsildar office, and threatened the authorities to issue patta or to give any favor, and threatened to commit suicide in front of this office, then such type of acts are considered as an offence under section 226. And again, the grievous hurt by a group of 5 or more persons on the ground of race and caste or community is also considered as a serious crime for which a punishment of 7 years is imposed under the new act. In sections previously, the causing of death by rash and negligent act was considered as an offence for which the punishment was given as a 2 years. Now it was increased to 5 years under the section 106 of the BNS Act. Then the clear-cut definition was given for the child and transgender in the new act, and in the definition of the movable property that was revised, that include the tangible as well as intangible property, and regarding the electronic and digital records is also included as a document under the new act. When the old IPC Act was passed, there was no computers, there was no electronic records, so there was no then the mobile property only tangible property. So now the softwares and other things, which is intangible, that are also considered as a immobile property. So whoever takes or committed theft, steals the software, is also shall also be held liable under the relevant act, relevant provisions, as if that software comes the set of software, such as namely the intangible property, has been included as a immobile property under the new act. And similarly, the electronic records and digital record is also included as a documents. So nowadays, even the electronic documents, electronic emails will also be considered as a document and will be taken into consideration for the purpose of evidence or to prove the case. Regarding the punishment is concerned, the imprisonment has been the term of imprisonment for the offences have been increased for 32 offences. For 32 offences, the punishment has been raised, and for 83 cases, the fines has been increased, and for 23 cases, the minimum punishment has been mandatorily imposed under the new act. These are all the various provisions of the various features of the new act, new criminal law, which is called as BNS Act. And regarding the sections, there are 356 sections under the new 358 sections, and there are about 20 chapters. The first chapter deals about preliminary, the second chapter deals about punishment, and the third chapter deals about general exceptions, and the fourth chapter deals about abetment, criminal conspiracy, and attempt. And the fifth chapter specifically deals about offences against women and the child, and the sixth chapter deals about offences affecting human body, and the seventh chapter deals about the offences against the state. The eighth chapter deals about offences relating to army, navy, and air force, and the ninth chapter deals about the offences relating to elections. Then 10th chapter deals about offences relating to coin, currency, notes, and the government stamps. And the 11th chapter deals about offences against the public tranquility. And 12th chapter deals about offences are relating to public servants. And the 13th chapter deals about contempt of lawful authority of public servants. And 14th chapter deals about false evidence and offences against public justice, which includes false evidence, frauds, fabrication of documents, etc. Then the 15th chapter deals about offences relating to the public health, safety, convenience, and decency and morals. And the 16th chapter deals about offences relating to religion. Then 17th chapter deals about offences against property. These include theft, robbery, extortion, etc. And the 18th chapter deals about offences relating to document to the property, under which forgery, falsification of documents will come. Then the 19th chapter deals about criminal intimidation, insult, annoyance, and defamation. And 20th chapter deals about repeal and savings. So the one of the important things we have to, I just wanted to share about this thing, about this act. So actually, strictly speaking, the old act is repealed and new act has come into force. So does it mean that supposing a criminal case has been filed under the old act and proceeding has been pending, just because the old act is repealed under the new act, does it mean that all the previous complaints or cases which is already filed and pending will be closed? The act itself will be repealed, and then how can, when the act itself is repealed, then how can the court conduct the case? How can the police can continue the prosecution? The question will arise. So further thing, the section 358 of the deals about this thing. It not only repeals the old act, it also saves the previous act. With respect to the proceedings already initiated, or with respect to the commission of offence which is already booked under, or FIR registered, or suppose the case is pending under the old act for the old cases, the act, this section clearly says that such type of cases shall be continued, and such type of as far as such type of complaints proceedings are concerned, the old act shall remain in force with respect to that cases, like what the section 358 says. So with reference to old cases, the old IPC will apply, or relevant application, relevant provision which is applicable under the new act shall be applicable. So that is the law passed under the BNS Act. So this is the salient features of the various features of the new BNS Act. I hope this video will be useful to all. So you may share this video to your friends and relatives, or who may be interested in knowing this criminal law. We have two channels. Razyak Sattamarivom is a Tamil channel. Razyak Law Tube is an English channel. You may watch the two channels, and there are a lot of playlists. You can click the playlist, and you can from in the playlist you can find out the relevant topic and clear your legal doubts, and you can enrich your knowledge. In addition to that, if you have any specific doubt, you may also contact the cell number. If time permits, I will give you reasonable. I'll give you. If the time permits, I will try to clear your doubts and give you necessary consultation. Thank you. Goodbye. Razia Kali.